Continuing education knows that at the end, students want to graduate, and we can help them do that because we take the time to really listen to their needs and we understand all the different options that are available across the campus for them.
We don't take a cookie cutter approach. We realize each student comes with their own story. So whether it's a part-time student looking to complete a degree program or someone just looking for online courses, we're there to connect them to the resources of the university.
I am a Chief Deputy District Attorney at the 20th Judicial District Attorney's Office here in Boulder, Colorado. I lead our appellate unit and also help with additional complex cases that we file here in the jurisdiction. For recording purposes, today is Thursday, April 11th. It is 1:45 p.m. and this is panel number 17990. And it is titled, Our Supreme Court on the Docket or in Someone's Pocket. Before we get started, the University of Colorado Boulder, Colorado's flagship university, honors and recognizes the many contributions of Indigenous peoples in our state. CU Boulder acknowledges that it is located on the traditional territories and ancestral homelands of the Cheyenne, Arapaho, Ute, and many other Native American nations. Their forced removal from these territories has caused devastating and lasting impacts. While the University of Colorado Boulder can never undo or rectify the devastation wrought on Indigenous peoples, we commit to improving and enhancing engagement with Indigenous peoples and issues locally and globally. We will do this by recognizing and amplifying the voices of Indigenous CU Boulder students, staff, and faculty and their work, educating, conducting research, supporting student success, and integrating Indigenous knowledge, consulting, engaging, and working collaboratively with tribal nations to enhance our ability to provide access and culturally sensitive support and to recruit, retain, and graduate Native American students in a climate that is inclusive and respectful. One other thing I'd like to mention is that we want to be sure you get a chance to ask questions. Here's how we'll handle the Q&A at the end of this session. We'll reserve that last 15 to 20 minutes for Q&A. We're using a note card system to receive questions from the audience. At any time in this session, simply raise your hand to request a note card and pencil from one of our producers. Please write legibly for me more than anything else. If you are a student, please note this in your question on the card. When you finish, raise your hand to hand it to the producer who will bring it up to me. I urge everyone to please make your questions brief and to the point. And with that, I'd like to do a brief introduction of each panelist. For more information on each of them, you can find their full bios on the CWA website. First, to my right, I'd like to introduce you to Ian Millhiser. Ian is a novelist and senior correspondent at Vox. His work currently focuses around the U.S. Supreme Court, the Constitution, and the decline of our democracy. He was previously a columnist for Think Progress, and prior to this, he served as a law clerk for a U.S. Court of Appeals judge for the Sixth Circuit. The Sixth Circuit covers a chunk of the Midwest from Michigan down to Tennessee. I also asked Ian for an interesting fact, which you'll hear about all of our panelists, and he informed me he is a black belt in Shaolin Kempo.
I know Kung Fu.
Yeah. We're glad to have Ian here. Thank you for joining us, Ian. Next up is Rebecca Buckwalter-Poza. Rebecca is an activist and advocate who provides commentary on the law, politics, and policy for all types of media outlets, print, web, radio, and television. For nearly 20 years, she has worked worldwide on policy projects and progressive campaigns. She has written and published articles for many well-known media outlets throughout her career, covering the U.S. Supreme Court, judicial nominations, and legal developments. Rebecca also recently visited Antarctica. It's their 7th continent. We're lucky to have her on this panel. Welcome, Rebecca.
Thank you.
And last but not least, we have Lisa Graves. Lisa is the executive director of True North Research, a national investigative watchdog group that works with journalists and others to dig into where the money is coming from that may be impacting public institutions, including our court system. She previously worked as a deputy assistant attorney general at the Department of Justice and for the ACLU. She's written op-eds for numerous national media publications and has appeared as a guest on several major news networks. And Lisa is also an abstract impressionist and does abstract finger paintings while not worrying about the Supreme Court. Thank you for joining us, Lisa.
Thank you.
So at this point, we're going to have each of the panelists up here give a few comments or opening statements, however they want to frame it. And so we'll go ahead and start with Ian.
All right, thank you so much. I guess I'm going to start by kind of pushing back against the panel title, because I don't think that corruption explains the behavior of the current justices. You know, the nice thing about corrupt people is that if you stop bribing them, they stop doing whatever terrible thing they were doing because they were being bribed. And these guys are not voting the way they are because they are on the take. Even Clarence Thomas. You know, these guys are true believers. They are ideologues. They believe they are doing good with the decisions they're handing down. You know, if there is an explanation for why Clarence Thomas receives so many lavish gifts, I think it's more likely that he's being paid to stay on the court than it is that he is being paid to change his vote in any particular case. But we do have the most partisan Supreme Court we have ever had in American history right now. The Supreme Court has always been a political institution, but historically, whether a judge was nominated by the Democratic or Republican Party has not been as strong of a predictor of how they would vote, at least in the most contentious cases, as it is now. You know, as recently as 2010, we had a liberal Republican, Justice John Paul Stevens. Both parties now are extraordinarily sophisticated in vetting their nominees. You know, the Republicans, I think, are still traumatized by Justice David Souter, the George H.W. Bush appointee. He turned out to be a moderate. And Democrats' vetting operation really isn't any less sophisticated than the Republicans. You know, White Houses, when they pick a justice, they vet that justice to make sure that the justice will be in line on the issues that the party cares about at that moment. And that means that when there is an issue that one political party has cared about consistently for a really long time across multiple administrations, you can expect the justices of that party to vote in lockstep. So the Republican Party has hated abortion for a really long time. And so it's not a surprise that the Republican justices all voted to overrule Roe v. Wade. They were vetted to make sure they would do that. You know, the Republican Party has hated affirmative action for a really long time. You know, most of you probably do not have an opinion on the structure of the federal administrative state, but I assure you that the Federalist Society has very strong opinions on it. And the Federalist Society, which functions very much as the legal arm of the Republican Party, you know, has been pushing for a while to shift power from the federal executive branch to the judiciary, because the executive branch is sometimes controlled by Democrats, and the judiciary right now is controlled by Republicans. And so we're seeing that happen as well at the Supreme Court. On those issues where Republicans have a consensus, the Republican justices vote together, and the same is true about the Democratic justices. But one thing that I think is a little interesting about the moment, one thing I'm trying to figure out what to make of as a Supreme Court journalist right now, is I think the Republican justices came in with a checklist, basically. And they moved with lightning speed once they had the majority to check the items off the checklist. You know, get rid of Roe v. Wade, get rid of affirmative action, overrule Chevron, for those of you who really care about administrative issues. They really moved as fast as they possibly could. And I think they've run out of items on the list. And what we're discovering now is that there are some issues on which the Republican Party is divided. Before Donald Trump, there was a widespread consensus amongst both political parties in favor of free speech. You know, there was a series of 8-to-1 decisions involving increasingly more offensive versions of speech. And in all of these 8-to-1 decisions, the Supreme Court said, yeah, that's protected speech. Because there is now a divide within the GOP, you know, not every Republican is Ron DeSantis. You know, not every Republican wants to ban books or passed don't say gay laws or whatever. And that is dividing the Republican justices. You've got Roberts, Kavanaugh, and Barrett, who are typically voting for the Democrats with the Democrats in free speech cases. And you've got Thomas, Alito, and to a lesser extent Gorsuch, who are generally voting for very restrictive readings of the First Amendment. I think disagreements within the GOP explain the Meafy-Prestone case. If you read the lower court's decisions in the Meafy-Prestone case, this was the case where some lower court judges tried to ban the abortion drug Meafy-Prestone. If you take their argument seriously, it would potentially require thousands of drugs to be removed from the market overnight. And, you know, I think Republicans are divided on the question of whether we should eliminate abortion by any means necessary, including preventing you from getting the antibiotics you might need to save your life. And so we are seeing divides. The note I will leave you on, however, is that Donald Trump has very strong views on these divides. You know, he is with Ron DeSantis and with Alito and Thomas on the First Amendment. And he will be more sophisticated if he gets a second term than he was in his first term, because he has more of an idea of what he is doing and who his loyalists are. And so while the Supreme Court we have now does reflect some divides between more traditional civil libertarian views that Republicans used to hold and the newer views that we see from MAGA Republicans, that equilibrium is not going to last. You know, we are going to see many more Thomases and Alitos, potentially, you know, enough to eliminate the pro-First Amendment majority on the Supreme Court if Donald Trump prevails. And with that, I'll pass it on to Rebecca.
Hi, Rebecca Buckwalter-Poza. My pronouns are she, her, and aya. I hate to be disagreeable right out of the gate, but I mean, first
Disagree away.
I mean, I wasn't asking for permission.
Not fair.
First, there's the title of this panel, Our Supreme Court. This isn't our Supreme Court. This is Donald Trump's Supreme Court. And then, well, Ian, you've said two really confounding things. The first is that the left has a vetting process anywhere equal to the right's vetting process for judicial nominations and confirmations. And I'd love to think that was the case, but if so, it's a very well-kept secret. Perhaps at the Supreme Court level, but not for the lower federal courts, which is where most of the decisions that affect people day to day are being made, if not in state courts, which are another important but separate conversation. And finally, Ian, you suggested Donald Trump is capable of sophistication.
I probably went too far on that one.
Way too far. So yesterday was my 1-year anniversary at Alliance for Justice, where I focus on judicial nominations and judicial ethics, which we could use some more of. And when I joined, it was just as some of the most outlandish news, should have been outlandish news, was breaking about Clarence Thomas. And at that time, it was still kind of funny to say, oh, guys, isn't it going to be nice when he just says, yeah, I've crossed a line, all right, I'm done. I think corruption is very much in play, but not in the direct sense. Yes, Clarence Thomas is hanging out on yachts, taking private trips. So Sam Alito, please don't forget when you're having that conversation. But the influence of money with respect to the Supreme Court is mostly about access. And that's what these trips add up to. It's not the dollars going directly into justices' pockets. It's about who gets their time, who had the last conversation with them about these issues, and who's shaping their thinking, who's rewarding what types of thinking they're doing. Well, God, one more thing I gotta disagree about. This Supreme Court is nowhere near out of issues or items. I mean, so this is, we'll get into this, I'm sure, but a really important aspect is the Supreme Court and the lower courts. Part of this right-wing vetting machine is the Federalist Society, is the pipeline of who as a law student is directed to which judge to clerk, is directed to which justice to clerk, is directed to which law firm to, and so on and so forth. But it's also the Alliance Defending Freedom, which is an organization that has thousands of right-wing lawyers that are bringing cases before these judges who've been groomed to hear these cases and generate the results that the right wants on these issues. And I think that perhaps the most stunning recent example of how this works and how effective this machine is the Second Amendment, which never stood for the individual right to bear arms, but over the course of, say, 30 years, through a coordinated effort, legal journals, mainstream media, judges, professors, every avenue you could think of, the right wing just reshaped it, re-envisioned it, and now from Heller we have Bruin, we have Rahimi's term, and I think the biggest target, and Ian did touch on this, of this present uber-conservative, uber-majority is the First Amendment. They're attempting to invert it. Instead of a negative right, the right to live a life free of interference, to protect speech, practice of religion, assembly, they're trying to create they have created a positive right to discriminate. In Mississippi, in an anti-LGBT law. In Texas, with another mob enforcement law, anti-abortion. And that's coming to the Supreme Court, and they've given every indication that is their intention. So, thank you so much for attending.
Yeah, thank you. Well, I'm honored to be on this panel and to see so many of you in this lovely and cool auditorium willing to hear more about the horror story that is the U.S. Supreme Court. I know there's an actual panel later today or tomorrow about horror films, but this is not that. It just may seem like that on occasion. I'm going to speak for myself and not assume that any of my panelists or our MC agrees with us, and so you don't have to, you can object if you wish, but your silence is not assent, because I'm not going to hold back. So this court is corrupted. Clarence Thomas is corrupted. He has been corrupted. I think we need an expansive conception, in fact, really a common sense conception of what corruption means. If in 1999, 2000, you say, man, I'm not making enough money to stay on this court, I might leave if I'm not really living in the lifestyle to which I think I should be living, and then suddenly a series of billionaires starts providing you fabulous vacations to stay on the court, to me, that's corruption. It's almost like, to me, black and white corruption. Now, that definition of corruption is not what the law says, what the law requires, is not what the totally ineffectual ethics code, meaning voluntary system of ethics, that John Roberts announced last year involves. But to me, it is fundamentally corruption. But that's not all. As Heidi Presbilla documented at Politico late last year, as the Citizens United decision was pending in 2010, actually in 2009, actually let me go back a second because it's even worse than that. That Citizens United decision was about a film called Hillary, the movie. It was a film that was set to run in 2008 when Hillary lost the bid to become president. That case was not, in essence, resolved. She did not become president. Obama became president in 2008. He was sworn in 2009. And John Roberts and the Roberts Court decided to hear that case in September of 2009, before the Supreme Court's term even began, early on, to get a decision out on Citizens United, and what that means is on the constitutionality of the Bipartisan Campaign Reform Act, BICRA, which was known as McCain-Feingold, which had very reasonable rules about things like, if you're gonna run an ad in the couple months before the election, people should know who the funders of that ad are. Otherwise, we have this massive loophole around disclosure and money going to candidates. You're giving them something of tremendous benefit through negative advertising, and there should be some disclosure along with some other rules. So the court hears that case in September of 2009. What happens next is that Jenny Thomas starts organizing a new group to take advantage of that decision called Liberty Central with Cleta Mitchell. I'm sure you've heard of her. She's the woman who was part of the perfect telephone call in Georgia. On New Year's Eve, Jenny Thomas rushes a filing to Virginia to get a nonprofit or to get her corporation basically authorized because Harlan Crow, the billionaire we've now heard so much about, had staked her with a $500,000 gift to Liberty Central to fund her operations and fund her salary. Then in January, that gets authorized, and in the second and third week of January, around the 21st of January 2010, Clarence Thomas sits on a case, a 5-4 ruling, 5 votes. If he had recused himself for the fact that secretly his wife had just received a $500,000 gift to her new nonprofit that he did not disclose, that would have been a 4-4 decision, and Citizens United would not be the law of the land. We would have, at least for some period, have had the Bipartisan Campaign Reform Act. And he had the audacity in that case to offer an additional opinion opposing disclosure. Of course he did, because he is fundamentally corrupt. But that's not all. When Jenny Thomas gets into difficulty for her public statements and people learn about this political group, this Tea Party group that she's organizing in the 2010 election to attack what was to be the Affordable Care Act, she ends up leaving Liberty Central, and she ends up getting paid through another Leo-tied group called the Judicial Education Project, at least $100,000 secretly through that entity passing money to Kellyanne Conway into her coffers, into the household of Jenny and Clarence Thomas, money to feather their nest, a 6-figure job. When Heidi Presbala asked them if this continued beyond 2010, 2011, they refused to comment. I think we have to assume that the easy answer would have been it stopped, not that we're not going to tell you whether it continued and for how long, and who has been funding Jenny Thomas's salary this whole time as she's been actively involved, most recently, in trying to subvert American democracy through that election. So I have more to say about this court. It's captured the series of cases that have attacked the structure of our democracy. I have more to say about how this court chooses cases. I have more to say about the nomination process. I will conclude by saying 2 things. One is, I was the lead counsel at the Justice Department on the Judicial Nominations Working Group, so I started vetting judges about 25 years ago. I was then the deputy chief of the Article III Judges Division of the U.S. Courts, which had oversight of the Financial Disclosure Office, which reviewed the financial forms that these judges filed that Clarence Thomas has repeatedly lied on. And I was also the chief counsel for nominations for the Senate Judiciary Committee, where I managed and oversaw the effort to try to protect our courts from unfair judges like some of the ones we're seeing in the courts now. The second thing I'll just say is, yeah, I'm happy to be here. Thanks for hearing me out.
Well, I think that's going to wrap it up. No, it's not. Obviously, it seems like we have a lot to talk about. So I wanted to touch on, there are a lot of topics we could go off on there, but I wanted to touch on one and just circle back to you to start, Lisa, because you came out of the gate strong with the corruption statement. Back in 1969, Justice Abe Fortas resigned from the Supreme Court after 4 years because it came to light that he accepted a lifetime retainer from a friend and former client for undisclosed legal advice he provided. And in doing so, he told the Washington Post, quote, "There wasn't any choice for a man of conscience." So I would assume, I'm going to guess you'll talk about this, but things have changed since then. But I think the bigger question is not only what has changed, but when did this change and why did it change?
I think that's a great question, and the parallels, between that scandal for Fortas and Thomas, there are parallels, except for that Thomas's situation is, in my view, much worse, much more damning, much longer ongoing, and he apparently lacks an ethical conscience, the conscience necessary for being a judge and being entrusted with making rulings or fair rulings in our judiciary. And I would say, I adore you, Ian. I think the world of Ian. I love his books. I love his writing on Vox. We don't agree on this definition of corruption, but we agree on so much more. In fact, probably most, I would assume, based on my reading of your work, most of the things. But I do think that this question of corruption, I had this question when I launched ALEC Exposed, and the question was, well, if they were going to vote anyway, like, how is that corrupt? They didn't change their vote. The lawmakers who are part of the American Legislative Exchange Council, they were going to vote for this bill or that bill, and I was like, yeah, but you don't get to keep the bribe because you were going to do it anyway. Like, that's not the standard for ethics and corruption. Now, it is under the law. There's a narrower definition of corruption. In fact, the US Supreme Court, in the City United decision, narrowed that definition of corruption further in terms of what might influence a candidate through this dark money pouring into our system. But the fact is that we have a couple of problems that are nested in your question. One is, in essence, our judiciary depends on having people who are devoted to being fair, appearing fair, in order to protect the integrity of the courts and the integrity of the decisions that are issued. And if you have someone who is not dedicated to being fair, or even the appearance of fairness, you know, an ordinary person would have resigned after these scandals emerged over this past year of Clarence Thomas's numerous trips, undisclosed gifts, and more. But he didn't. In fact, you know, he basically doubled down. He did not recuse himself from the decision, the Colorado case, that was before the court just a month ago. That case, he certainly should have recused himself because of his wife's role in not just, you know, calling Mark Meadows or texting Mark Meadows incessantly to try to get him to support him in trying to stop the actual counting of the votes of the American people in the 2020 election. She also worked to try to stop those vote counts through emails to legislators in Wisconsin and Arizona, we know through open records requests, perhaps more. He did not recuse himself, and Roberts allowed this. Now, there's a question, can the Chief Justice do anything? Could he do something? I think he should do something. The fact is that he basically allowed Thomas to sit on that case, in essence asserted that it was a unanimous decision. It was a decision that involved a sort of a unanimous view that one state should not be able to sort of dictate the results of the election by keeping Trump off the ballot. I have two words for you, I guess it's three, Bush v. Gore. So only in this instance does one state is not able to make this decision. But leaving that aside, when you looked at the decision, what you saw was 4 justices actually dissenting from this notion that Congress would have to affirmatively create implementing legislation in order to block someone from the ballot. What that means is there were 5 justices saying that you need affirmative legislation, but in reality there were 4, because Thomas should never have been able to sit on that case. And any one of those justices, including the concurrence or dissent, should have called him out. Roberts certainly should have, but Roberts has been party to this. Roberts has allowed this culture of corruption to engulf this court. He has thwarted every effort to have meaningful congressional oversight for ethics. He is an enormous part of the problem. He is partly responsible. And I'll just end on one particular point about that part of the 14th Amendment. You know, the 14th Amendment, its first clause is about equal protection of the law. It's one of the most beautiful, important parts of the reformation of our Constitution that was written. The second part is this clause that if you just read it, it says that Congress, by a 2/3 vote, can remove the disability of being barred for office for participating in an election. Oh my God. Wow. That is the worst Freudian slip I've committed in like 25 years of public speaking.
I see why it's so hard to get the 2/3 vote.
Yes. Oh my goodness. Okay. My sincere apologies to you and the viewing audience. I'm very excited about this topic. No. Oh, I doubled down. Okay. In order to remove this disability for running for election, Congress, in the plain language of this Constitution, says you need a 2/3 vote by Congress to remove this disability. Not that you need to implement it through implementing legislation. It's the opposite. And so that decision, that 5-vote decision on the Colorado case, I think is another example of the fundamental corruption of this court, the way they're willing to put their thumb on the scale of justice. We'll see what happens in the immunity case, but quite frankly, in my view, they have not earned, nor do they deserve, our trust that they're going to do the right thing by our Constitution or by the laws of the states and the federal government. That's my view.
So I'd like to make 2 quick points. I mean, one is to try to turn down the stakes on this conversation about what corruption means. Because, again, my original point is that these guys are worse than if they were corrupt. I mean, Clarence Thomas clearly is on the take. He should resign immediately. My point is that these guys are doing what they are doing because they are so dedicated to it. They are so committed to trying to rebuild the nation in their image. And this is a fundamental shift from how the judiciary functioned for nearly 100 years. And, and a shift away from one of the most hard-learned lessons in our constitutional history. So if you go back to the beginning of the 20th century, this is what was known as the Lochner era. And you had a bunch of justices who would essentially make up new rights in order to strike down laws that they did not like. The Lochner decision was a case that invented, actually there were earlier decisions that referred to, but was part of a series of decisions that invented something called the right to contract. You know what the right to contract was? It was that if you enter into a labor contract where you'll have to work 116-hour weeks for almost no pay in horrid working conditions, the government could not do something like pass a minimum wage law or a law giving you the right to unionize in order to mitigate the harshness of this labor contract that you entered into. That was the right to contract. It was the right to be exploited by your employer. Appeared nowhere in the Constitution. And this was just how the Supreme Court functioned. They just made shit up.
Yep.
They made up a reason to strike down child labor laws. Hammer v. Dagenhart, 1918. They said that it was unconstitutional for the federal government to ban child labor. And then Roosevelt came in, and Roosevelt kind of went to war with the Supreme Court. And Roosevelt, to his credit, did not say, I am going to appoint justices who will implement the New Deal from the bench. He did not say that, I'm just going to take this thing that the court has always been doing and turn it into a way to permanently lead my rule forward after I am dead. Roosevelt believed in democracy. And so he appointed justices who believed in deference. There are a number of deference doctrines. Caroline Products, which says that generally all laws arrive with a presumption of constitutionality. There are exceptions for it. The exceptions largely have to do with preserving the democratic process. The Chevron case that I mentioned earlier is a deference case. It says that when there is a federal law that arguably gives a power to make a policy decision to a federal agency, it should be made by the agency and not by the court. And the reason why is the agency is responsible to a president who is elected. And so if you don't like what the agency is doing, you have a recourse. What this court is doing is it is dismantling all of these hard-learned lessons that we want the Democratic branches. We want the Congress and the presidency doing it. And at the same time that they are making decisions, if you look at the student loan case that they decided recently, you could not write a clearer law than the HEROES Act, saying that what Biden tried to do with student loan forgiveness is lawful. I can get into that in more detail if you want. But they are overriding the text of clearly defined statutes. They're once again making up new doctrines that appear nowhere in the Constitution or any law in order to achieve their policy goals. And they're reversing what Caroline Products said. Remember, Caroline Products said the rule is deference. Yep. The exception is we want to preserve democracy. But they are saying states can gerrymander. They are dismantling the Voting Rights Act. They are giving us Citizens United. Yep. And so the problem that I see, the biggest problem I see with this court, there's definitely a problem that Clarence Thomas is on the take and he should resign. But the problem I see with these guys isn't that for the most part, they're using their jobs as a way to enhance their income. There's an old quote that if you've been to law school before, you've probably heard a million times from Judge Learned Hand. The spirit of liberty is the spirit that is not too sure it is right. These guys are convinced they are right about what America should be. And they're so convinced that they are willing to overrule the will of the American people as expressed through our democratic branches over and over again based on made-up doctrines. And that just scares me a whole lot more than the fact that Clarence Thomas likes to spend his vacations on Harlan Crow's yacht.
Thanks, Ian.
Ian, you've led me directly to a topic I'd love to address, and I apologize. As a lesbian, I don't know much about erections, so
I'll never live this down. I'll never live this down.
Man, this is going to keep going.
I'll pretend that wasn't a continuation. What I do know a lot about, because I started researching it back in 2016, is judicial impeachment. And that's something that I would love to see discussed more often, because Clarence Thomas shouldn't just resign, he should be impeached. Judges have been impeached in the past for being drunk, for other things that, I mean, you mentioned Abe Fortas, which what was going on with Justice Fortas was a world apart from what Thomas, from what Alito, from what Kavanaugh, whose $250,000 debt vanished between his nomination and confirmation, have been up to. And anti-Semitism was a significant part of what happened with Justice Fortas. He didn't know, actually, where some of the funding came from. And, I mean, that leads to the, an honorable man has no other choice. It's just a totally different conversation. So yes, impeachment needs to be more than on the table. We also need to expand the lower courts. They're overdue. Until the 1990s, it was a matter of process, not a political thing, that as population increased, as caseloads increased, so too did the number of seats in the judiciary. Why does that matter so much right now? Donald Trump appointed 234 Article III judges to lifetime appointments, many of whom were younger than anyone on the stage. Sorry, presumptuous, but and so I'm interested. I mean, you've caught my drift in solutions, and so there's term limits. There's the expansion of the lower courts. There's the Term Limits Act that Representative Johnson has backed. Is interesting. It says you serve 18 years, after which you take senior status. And it ensures that essentially presidents get to alternate their appointments to the Supreme Court at a balance of influences, which is not to say that we shouldn't be discussing expanding the Supreme Court, because that too is an important avenue of mitigating undue influence. And the third thing that I bring up, in part because I think it's an interesting idea, thank you for your Second Circuit reference. On the Second Circuit, when it was discovered that a judge was corrupt, it became, I believe, informal, not even necessarily codified, but the practice of that circuit not to follow anything that would otherwise be precedent if the deciding vote was cast by the judge who was guilty of corruption. So imagine the United States tomorrow if the Supreme Court stopped following any precedent in which the deciding vote was cast by Clarence Thomas, was cast by a justice that we know to have been improperly influenced. I think that our standards for judges and justices have fallen far too low.
So one thing that you brought up, Ian, was President Franklin Roosevelt, so FDR, and how he appointed justices. And one of the questions I had here was, at his second term, when he won in a landslide, and some would argue he had a mandate, there was discussion of the court packing plan. And so, in effect, the president would be asserting his influence on the court, and however you view those justices, by adding more justices to obviously ensure that those folks have more of an impact. So my question to you is, understanding that we have 100 years back almost, a history of a president attempting to influence a court through an action that is arguably not constitutional, and I think in large part that's maybe why that failed. What's different now? How is that different than what we see today?
So I mean, the thing about court packing is it is simultaneously like the most severe sanction that Congress could impose on the Supreme Court, and also the one that I think is unquestionably constitutional. The Constitution does not say how many justices should sit on the Supreme Court. It is set by an act of Congress. The original Supreme Court had 6 justices. It has been as low as 5, and it has been as high as 10. So the number has fluctuated. Congress could tomorrow decide that we have a 15 justice Supreme Court. Biden would fill the seats, and and then we would have a 9-6 Democratic majority. So that is something that the Congress undoubtedly can do. The reason why people are reluctant to do it. So if you want to consider court packing as a solution, I think we need to be clear-eyed about what the result would be. It would be a discrediting of the federal judiciary as an institution. I mean, so long as the executive branch is still willing to have the U.S. Marshal Service enforce the Supreme Court's decisions, they'd still be enforced. But a Republican administration isn't going to enforce the decisions of a 9-6 packed Supreme Court. It would not be an effective method of doing things like bringing back Roe v. Wade. What I think would happen if we packed the court to bring back Roe v. Wade is there would be massive resistance. Clinics would stay open in Texas for as long as the federal government was willing to send law enforcement officers or potentially troops to stand outside those clinics and prevent the state of Texas from shutting them down. If that did not result in a civil war, it would end the minute a Republican president came into office. The reason why you engage in court packing, and I have gone back and forth on whether or not this court has crossed the line, is because you believe they have done so much harm to the democratic process, or there's such a threat to the democratic process, that it is no longer possible to reverse what they have done through the electoral process. I was worried for a long time that we had crossed that line. Last term, there were 2 voting rights cases that went better than they could have. And so I am unsure whether we have crossed that, whether we should deploy this very serious weapon, the most severe weapon that Congress has, in order to deal with the rogue Supreme Court. But I guess the thing that I am emphasizing, besides the fact that I am ambivalent on whether this court is so bad as that we should deploy that weapon, is that deploying that weapon is not a costless act. It would mean that decision, it would mean, as I said, a discrediting of the institution. It would lead not just to massive resistance when the court overturned precedent, but is Texas really going to follow Obergefell anymore? Is Texas really going to follow Lawrence v. Texas anymore? Is it really going to follow all of the decisions that Republicans don't like that precede this court? If the court has been so discredited. So, I mean, there are circumstances under which that weapon should be deployed. And, again, I just think that we should be cautious of what happens the day after it is.
I think when I think about this issue, I think of it as unpacking the court, because this court has been packed. The fact that they, in essence, stole the seat that arose when Justice Scalia died in early February of 2016, held that seat open for more than a year in order to install Neil Gorsuch into that post. Then, we can talk about Kavanaugh at length. I spent a lot of time talking with the media and others about Kavanaugh's unfitness for this court. And then you have, obviously, what we all know happened with Amy Coney Barrett, where she was installed a month before the voting day on the election, as people were already voting Trump out of office. And so the court already was reduced in size for a year, and that was fine with them, as long as they got to put who they wanted on. And then at the last minute, before this most recent presidential election, they put someone on very speedily, and immediately that was almost like a coronation of Amy Coney Barrett, because they knew that they would have the vote to enact this second part of their agenda. in terms of the egregiousness of this court, you know, I don't think that the decisions that have been issued are as bad as Dred Scott, Roger Taney's decision that provoked, in essence, the Civil War. But I think John Roberts is going to go down in history as the second worst Supreme Court Chief Justice in American history for the destruction that he has wrought on this country. After he was confirmed and Alito was swapped in at the urging of Leonard Leo for Bush's lawyer, Harriet Miers, who Leo believed was not doctrinaire enough because they were concerned about having a David Souter. What does that mean? They were concerned about having a fair judge who might actually follow past precedents versus do their bidding, which is what they got with Alito. Shortly thereafter, they made one of the most radical decisions in US history, which was to overturn more than a century of legal precedent about the meaning of the Second Amendment, inventing an entire new version of the Second Amendment and sort of mooting out the part about a well-regulated militia. That came, you know, to fruition then about 10 years, you know, more than 10 years later, in the Bruin decision authored by Clarence Thomas, which asserted a completely outlandish, ridiculous notion that the only gun laws that can survive are ones that would somehow pass muster or were equivalent in some sort of way with the gun laws of 1791 or perhaps 1865. That is an absurd and outrageous redefinition of the standards for review for our laws, and one that is just fundamentally at odds with the transformation of America in this period, including the broadening of the right from only white men with property, the right to vote, to being a more inclusive, multiracial democracy, which we are. The fact that we are now seeing zombie laws re-emerge in Arizona, for example, this week, along with the threat of it re-emerging in Wisconsin and other states, laws that were passed before most of the people who are in that state now could even have voted. Women, no right to vote. Again, on the Supreme Court's, you know, cavalcade of wisdom, they had a decision about 125 years ago that claimed that women did not have the intellectual capacity to practice law. Obviously completely wrong and ridiculous, I'll just say, on behalf of women everywhere. But you know, this court is not a deity. It's not perfect. It's not entitled to maximum deference when it has engaged in these activities. And I'll just kick through a couple more, which is Citizens United, another decision where they recrafted our First Amendment to say that you can't regulate this outside money coming into our elections, which has injected a tsunami of cash to try to distort our democracy. As Ian mentioned, the voting rights case, Shelby County case in Alabama, one of the key states in the Confederacy, Chief Justice John Roberts takes it on himself to nullify a congressional finding in 2006 in which I think there might have been only 12 members of Congress from either house who voted against the reauthorization of the Voting Rights Act for 25 more years. But Roberts decides that he's got the votes to destroy the key enforcement provision of the Voting Rights Act. And then, to just bring this full circle on this, and I won't get into redistricting, which is a whole other issue, or Chevron, which I hope we get to again, but what this Supreme Court did in 2022 was allow that Alabama district to stand, that malapportioned district to stand, even though it was clearly in defiance of another provision of the Voting Rights Act of 1965, allowed that to stand along with other states during the 2022 midterms, and had the court enforced that provision at that time, Democrats might have held Congress, because that's the impact. Those malapportioned districts in a number of states stood, and then after that election, the Supreme Court said, oh yeah, well, we are actually going to enforce it and make Alabama redraw these maps. So I don't give them much credit for actually continuing to follow the law that they were supposed to be following before 2022, after 2022, and now they have some machinations that they might engage in again in this 2024 race. And in fact, already one of these districts is proceeding, not in Alabama, but another southern state, North Carolina, without, right. So, thank you, audience. I appreciate that, Duncan. But the fact is that I don't think this court is behaving like a court. I think it's behaving like robed politicians who are advancing a political agenda without regard to the consequences to the real lives of the American people, and without regard to the consequences of the structural changes that they have worked to undermine our very democracy. Right.
Rebecca, any thoughts on that?
Well,
I mean,
Several?
much like our majority, I'm not going to run out of thoughts, but I would love to know if there are questions from the audience that will permit us to engage.
Yeah, let's start actually with you. Let's do that. So, first question we've got is there any way to fix the rules or non-rules that led to Merrick Garland's non-nomination?
Or non-confirmation. I'm not sure that there are, because the Senate is not obligated to confirm. They have the right to advise and consent. But there are reforms that Rebecca mentioned in terms of term limits, things that would sort of regularize the process of how vacancies arise, how long someone can stay, and reduce the incentive of putting people like Clarence Thomas at age 40, 41 on the court for 40 to possibly 50 years. Because they could serve much longer than any founding father envisioned someone serving on a court. And the Republicans have gamed that system in order to basically maximize the hold of their majority regardless of presidential terms. So there are reforms. I don't think anything would necessarily fix that, but you may have ideas, Ian.
I mean, y'all should come to my next panel, which is about the voting rights panel, in which I will rant against the United States Senate. Like, the fundamental problem, the single biggest problem in our democracy, bigger than Donald Trump, is Senate malapportionment. The 53 Republican senators who allowed the Garland nomination to be blocked represented, I've got the number here, 15 million fewer people than the 47 Democrats who would have voted to confirm Merrick Garland. The Republican Party has not won the popular vote if you just aggregate like across the last 3 Senate elections and add up all the votes. Hasn't won the popular vote for a Senate majority since the late 1990s. And like that's the reason we have the Supreme Court we have right now. It means that Republicans, when they're in power, can nominate their dream nominees, and Democrats can't get anyone confirmed at all if there's a Republican Senate, and they have to pick someone that every Democrat will sign on to. In the alternative universe where where senators were chosen in free and fair elections, we'd probably have a 6-3 Democratic court right now.
Yep. I defer to everything Ian just said.
Well, I'm going to agree with you for once here.
We normally don't disagree this much.
Sure. No, I mean, I think that there are many structural problems with the Electoral College, with the Senate, all of which play into this. But then there are also political problems. And that's a harder pill to swallow. And one of the things that I do at Alliance for Justice is try to convince senators that judicial appointments are really important, that it is essential that we fill every seat that is open right now before the election, and that judges take senior status or retire of their own volition so that there is an appropriate level of turnover in the federal judiciary, and that we have a more representative judiciary. But that could be its own panel as well. So,
I support everything she said too.
We just got a question, Rebecca, and I wanted to start with you. So you mentioned the concept of impeachment. Who would need to do what, and how would we begin the process of trying to impeach Clarence Thomas?
I wrote that article, but I didn't bring it with me. And the dog ate my homework. I mean, I think that people throw around the term the Overton window a lot. I think the first thing is simply to enter impeachment into the conversation that we're having, because much as Ian alluded to, this sort of threat of an arms race, if you start creating additional seats, which I don't think is actually something that would become an endless problem, and we're strikingly not in full agreement on that either. But I do think that impeachment is something that carefully wielded, thoughtfully wielded, is a tool that is now not just possible but incumbent upon us to pursue, because it is the mechanism that was created in the Constitution to solve problems like, frankly, Donald Trump, and like judges and justices who are corrupt, who are not suited for office, not fit, as Lisa said. I'm rusty, but I think that there are multiple mechanisms for initiating impeachment. It can actually come from states, and also through the sort of representatives and senators, but I think the most important thing is that we broaden the conversation, and that we're actually discussing impeachment, and that it's a serious thing and not treated as a political weapon for a lie that's not consequential to the office that someone holds. And there's a lot of work to be done to rehabilitate the idea of impeachment, for it to be understood seriously and undertaken. So I'd love for it to be as simple as saying, well, the parliamentarian does this, and then we need 5 senators to do that. But I think the first thing is the conversation has to change.
And I just want to agree with that and say that the idea that someone could remain in office despite what the investigative reporters have helped uncover about Clarence Thomas, and quite frankly, if it had been uncovered about Scalia, he should have been subject to impeachment too, but can't do that now. He was on the gravy train in an extraordinary way, was sort of helped mentor Thomas seemingly in some of these tricks of the luxury lifestyle of Supreme Court justices. But I think Rebecca's exactly right. We have to have that conversation. If he's not worthy of impeachment based on this series of activities and failures to disclose and gifts, what do the ethics standards mean? They basically mean nothing. But you do need, in terms of the House process, it has to begin in the House, and until there's a progressive House, there can be no impeachment of Clarence Thomas even really begun, although someone could file, but it won't go anywhere in this particular House. But there are, mechanisms to raise it, and I do think we need to be having that conversation because it's about the fundamental integrity of our courts and whether we are living under rulings that are actually legitimately being issued that affect our rights and our lives. And I think that's a fundamentally important question for the American people to address. And I see people responding to this court and saying, we don't trust it. Under John Roberts, the support, public confidence in the court has plummeted, not just because of the Dobbs decision, but certainly in part because of that Dobbs decision reversing Roe versus Wade in nearly 50 years of legal precedence, but also because of this cloud of corruption that has been revealed by tremendous reporting, and not by the activities of John Roberts as the head of the Judicial Conference or the head of the Administrative Office of the U.S. Courts, not by him doing anything to actually protect the integrity of the courts, the integrity of justice, the quality of justice for Americans, but in his inaction. This has been because of investigative journalism.
And I want to jump in here because in one of my other past lives, I was a polling nerd. It is an astonishing thing how salient the Supreme Court has become as a matter of public opinion. The number of people paying attention to the Supreme Court, never mind the fact that they have record low trust levels, approval ratings, the number of people paying attention. And perhaps I know we've got a lot of negativity, but that's one positive thing. It is remarkable and very important, and something that we must encourage with every atom, that people are paying attention.
So I'm in the unfamiliar role of being the conservative on this panel. So I guess I'll just point out that the magic number when we're talking about impeachment is 67. You need 67 senators in order to remove someone. And we have a recent precedent in which the President of the United States incited a lynch mob to try to kill the members of the United States Senate. And the result was we got 57 senators who had enough of a self-preservation instinct that they would vote to convict that president under those circumstances. So Clarence Thomas has many vices. As far as I know, he has not incited anyone to attempt to murder a United States senator. And so I'm just really pessimistic about the prospects of the impeachment process.
I want to honor that, Ian, because I mean it is the case that the Senate does not have a currently good record at all of being able to impeach people who engage in the most egregious attack in the form of Donald Trump. And at the same time, I think, and I know that members on the Hill don't necessarily agree with, I'm not in charge of the universe as it turns out, but people don't want to begin a process if you can't win. In essence, this is a common process both in politics and other ways. If you think you can't win, you don't start the process. But I think there are matters of principle where we're starting the process and seeing where it goes. And if it turns out that people decide to defend Thomas's corruption, as we've seen on the Senate Judiciary Committee on the Republican side, trying to stop subpoenas being issued to investigate this matter, then I think that the American people have a right to know where they stand and to take that into account in their votes for or against those members.
Ian, I'll throw this one to you.
All right.
How do you believe the court is likely to rule on Trump's claim of presidential immunity, and when do you expect a ruling?
You want my honest answer to that?
I believe they do.
Who the fuck cares? and here's why. They've already delayed his trial until after the election. That was the ball game. That like whatever they say in that immunity decision, I don't care. Trump argued in the lower court that the president is allowed to send the Navy SEALs to kill their political rivals. I hope they don't say that. I don't think they're going to say that. I think they're probably going to rule against him. And then I think a bunch of credulous reporters will probably rely on the fact that they ruled against him to create the impression that it was some kind of a No, Trump already won that case. That case has already been decided. The good guys lost.
Yeah, and I do think that this court chose to put that as the last argument of this term. During the Nixon crisis, the court, heard that U.S. v. Nixon case on an expedited basis and ruled on an expedited basis. This court, the Roberts Court, chose to take a case that they could have simply denied cert on because there was a unanimous decision by the D.C. Circuit that Trump's immunity claims were outrageous, unacceptable, inconsistent with the law, and yet they took this case in order to have that effect, the effect that Ian describes, that the delay is the victory for him. But there is a campaign that's launching, I think, this week called, #JusticeCan'tWait, to really try to make sure people understand that that this court is really, whatever the court decides, it's actually not really in our favor. It's not really defending us because it's already slowed and delayed the process as it is to try to delay the process of getting justice and getting him tried in D.C.
I think this is a good moment to also acknowledge the hypocrisy of this court, which is manifold, but the shadow docket, the abuse of political question doctrine, the development of all of these sort of shady ways of manipulating what they hear, how and when, skipping appellate courts altogether, those that are not, for example, like the Fifth Circuit, which is Texas, Louisiana, already completely geared toward generating the results they want. There is nothing normal or ethical or acceptable about the Supreme Court plucking cases directly from the district court to hear without need, without provocation, without ripeness. And then to take a case that they shouldn't have from the DC Circuit and then delay it. I am also, I do confess, personally bitter because I sued Trump while in office under the First Amendment. We won in the Southern District of New York. We won at the Second Circuit. The Second Circuit declined to rehear en banc. The Supreme Court elected not to hear the case until after Trump left office so that it could reach the result it wanted, which was to say, well, it's moot now. The same Supreme Court, well, not exactly the same, but essentially, they heard two cases on Halloween of last year that presented nearly an identical question. So it's personal. But this court's shenanigans are just overt. There's nothing, they're not whispering. It's a shout. And it's just stunning.
I just want to jump off a point you made about how this court often engages in procedural irregularities. At the very least, and they owed us a lot more, But at the very least, when they handed down one of the most consequential decisions of the term, the decision to delay Trump's trial until after the election, they owed us an explanation. Typically when the court decides a matter of such consequence, the justices who agree with that outcome write a lengthy essay explaining why they reached the result that they did, and the justices who disagree with that outcome themselves write a lengthy essay explaining why they thought that was the wrong thing to do. At the very least, they owed us a goddamn explanation for why we don't get to have a trial we don't get to trial possibly ever, because if he wins, then he can order the Justice Department to dismiss the charges.
It is incredible that some of the biggest and most important decisions this court is making are not on the merits or even directly deciding a case. They're these procedural maneuvers. And
yeah.
I can only hear out of one ear. I'm sorry, I didn't get that. But yes, yeah. Well, I mean, and the thing is, too, it's very telling that not even these justices, who are certainly not shy, want to be on the record for some of the decisions they're making. They'd rather come out per curiam. And I think that the hardest job in America right now is probably to be Ketanji Brown Jackson, Elena Kagan, or Sonia Sotomayor. They work incredibly hard at cabining decisions, at narrowing decisions, at intervening where they can. And it's not surprising that Justice Sotomayor recently, for the first time, I think, really kind of stepped out to say that she lives in frustration. So to be a straight justice, an ethical justice, someone who cares about the law, and to be in this position where the best, and Ian and I discussed this before, a victory at this court is this court not taking a case, or this court opting not to rule on it. And it doesn't even, I think we can't even hope for as much as following the law most of the time. And I think it's important to recognize that, because it's also very difficult, also as a Latina lawyer, to see these criticisms of these three justices who are doing the hardest job in America. And they're doing everything they can to preserve justice. And it's out of their hands, which it shouldn't be.
So I want to thank everyone for their questions, and I've got about a minute for each of you before we wrap up. But I think this last question sort of maybe lets you sum up where we are. I'll start with you, Lisa. How much respect should be given to this current court?
Well, in ordinary human nature, I believe that we should treat everyone with respect. But I think when it comes to institutions, if those institutions have defiled themselves or been defiled, that we have to speak out against that corruption. We have an obligation, a moral obligation, to speak against that corruption and call for action to redress it. Just two quick things, super quick. One is, this court, its docket is almost entirely discretionary. It's only hearing 60 to 70 cases a year. It is choosing to hear affirmative action. It's choosing to hear a gun case, choosing to hear an abortion case. It chooses those cases as a matter of its discretion. So it's basically setting its own political agenda of what rights it wants to unwind at every single term. Only like state versus state cases does it have to take. And the last thing I'll just say, just a PSA, which is Duncan and I have a radio show on KGNU for you local Coloradoans. The last Friday of every month, April, May, and June, at 8:30 in the morning, to continue this conversation. So, thank you.
It is my position that it is critical that we not respect this court. It is not due respect, and it would be a violation of what the Supreme Court is meant to be, to treat this court as if it is legitimate, as if it is entitled to the respect that a court that operates with integrity as the third pillar of our democracy. And I think, I'm reminded by, they came for X and they came for Y. And by the time they came for me, there was nobody left. We need to speak out now and apply scrutiny now. Because what has been done to this institution is unacceptable, undemocratic, and illegitimate.
So I guess my answer is that we should give them exactly the same amount of respect that you would give to Mitch McConnell. And what I mean by that is that, like, there's a mystique that surrounds the Supreme Court as if they are somehow removed from politics, and they are not. They are political appointees who are appointed by partisans in order to achieve partisan ends. You know, they don't serve for elections, but I think we should criticize a justice in the same way we would criticize any elected official that who is doing something that we don't like, and in the exact same terms. You know, and I think that this especially applies to us lawyers. One of the purposes of law school is to teach us to reflexively approach judges with a sort of ritualized obsequiousness. And when you are representing a client, there's a good reason why you engage in ritualized obsequiousness. But if you are not in the unfortunate position of having to represent a client in front of this Supreme Court, you know, again, like, I don't think you should go out of your way to, like, well, you should speak of them the exact same way that you would speak of Mitch McConnell.
So thank you all for coming today. Let's give a round of applause to our panelists. Thank you for your great comments.
Thanks a bunch. It was a lot of
Yes.
fun.
We appreciate it. Take care.
Yeah, wasn't expecting my...